What are you doing?
Just celebrating our big settlement win, baby. And who do you think you're fooling in that stupid suit?
What? I'm a successful litigator now. Maybe I should dress like it.
Really?
Yeah, I can't do this for a whole video.
Nice, much. Anyway, where were we? Oh yeah, we settled. All right, if you're here, you're probably curious how I won my lawsuit. So today we're going to talk about negotiable instruments, how you can use that knowledge to your advantage, how to use billable hours to your advantage, what to expect if you sue and end up having to deal with arbitration, and then how you might win by private settlement, just like I did. Let's get into it. While I am going to take everyone through the play-by-play, let's start and set the stage for some of the people who might be new here or new to the channel. My name is Jack Slater. I'm following in the footsteps, essentially, of Brandon Joe Williams and his research on the Uniform Commercial Code, specifically Article 3 of the Uniform Commercial Code, which deals with negotiable instruments. These bad boys right here. What many of us may not realize, unless you're into this already, is that a payoff statement, like from your auto finance company, that is also a negotiable instrument, as well as the promissory note that you sign and the agreement that you sign in the process of purchasing the vehicle. We're not going to get into that today. My method was following the Brandon Joe advice of tendering a payment by using their payoff statement. So I had already acquired a car, asked for the payoff statement about 2 years into it, so I'd only paid a little bit off the total balance, which was about, let's say, $16,000 still remaining active on the loan, one of those high interest loans for those of us who have hammered credit like I did at the time. And so the ability to enforce this and this actually fall under the same guidelines, the Uniform Commercial Code. Negotiable instruments. 3104. So that's what I did, and in most of us who undertake something like this, you deal with the refusal and the rejection of your tender of payment using your negotiable instrument, and so many of us find ourselves in the position of having to litigate, to sue, to pursue via court, and get remedy and compel performance. So let's take you through the timeline. It was about December 2024 when Brandon Joe had released his map, his flow chart, which for me, being a visual learner, that was super helpful to really digest this and be able to make a plan and move on that plan. So January 2025, I had decided when the last Federal Reserve note payments would be made, so I could immediately move into the strategy of requesting the payoff statement, getting the payoff statement, using an endorsement stamp similar to this. You can write it out as well, but the stamp turns your negotiable instrument into something that can be tendered, right? It's an instrument, you've made it negotiable with your qualified endorsement, and at that point, it's a matter of properly tendering it back to the institution that provided the instrument. You are the holder in due course of the instrument because they sent it to you. That gives you the ability to negotiate the instrument, which is your endorsement, and then tender it back to them as if it was a stack of these. Negotiable instruments cover bills, notes, drafts, orders to pay, promises to pay. This note is legal tender for all debts, public and private. This payoff statement is an order to pay. They're both defined the same way under Uniform Commercial Code, so that's what we're using to our advantage. So I requested the payoff statement, I performed on the payoff statement right away, and I tendered it back to them using registered mail, assuming that they would probably reject it, which they did. Many of us find ourselves in the position of getting called a sovereign citizen. You believe in vapor money theory. We're not accepting your paper contract. Nice try. Go away. I just took that as evidence. I ignored the calls and subsequent letters that I got, and then once they repossessed the vehicle, I was able to claim harm and damages to my sole proprietorship, i.e. the all caps name, or some people call it the straw man. It's more appropriate now, given what we've learned from Brandon Joe, to just call it the sole proprietorship. Keep it simple. You're the agent, for the sole proprietorship. So while I got the refusal letter in, say, mid-April-ish, by May they had damaged my sole proprietorship. They repossessed the vehicle, costing me about $7,000 total, $1,000 a day over 7 days. They impacted my credit, which I got denied for a loan, causing damage of about $10,000 by not being able to get a backup vehicle. I had to pay extortion fees of around $2,500 in Federal Reserve notes to get the vehicle back. And then the reputation damage, because the vehicle happened to be repossessed from a friend's house who was also a client of mine getting services, and so I was able to claim reputational damage. Emotional damage from getting impacted while I was at a business location. And so another $10,000 there. So I had a nice stack of damages to be able to build into my complaint. Prepped and filed the case based on Brandon Joe's video interview with Joey Kimbrough, where they discussed a lawsuit needs to have duty, breach, damages, right? What was their duty? How did they breach that duty? Like, they didn't follow the law per U.C.C, and then they damaged the sole proprietorship due to the actions that they took. And so it took about 2 weeks to serve that case. It took about a week and a half probably of, building the case and getting your 3 copies and just getting it ready to file, getting your argument prepared. I've made a lot of that easier because I'm able to provide a template of sorts for how my argument was structured. And every step of the argument was made another line item, another numbered line item, another numbered line item. So every time you took a step in the scenario, you're outlining that as another fact that they have to rebut. And the better you can break out those facts, the more difficult it makes it for the bar cards to argue those facts, especially when every one of them is supported by state law, right? Received the payoff statement, which is a negotiable instrument per U.C.C. and Arizona Revised Statute 47, negotiable instrument defined, right? It tendered that as a payment, tender of payment, cited, U.C.C. Every step of the complaint was supported by state law, and the advantage to doing that is by not putting all of your facts together in a paragraph and numbering that paragraph. A good lawyer can say, hey, there's, the car wasn't blue, it was red. And so you might have all these facts in this paragraph, but because you messed up one of the details, they can call that out and strike the whole thing, the whole paragraph from your argument, and it makes it easier for them to argue the more you bulk your facts together. So break them out into individual items, making it that much harder for the bar card to go through and have to refute every single one of them. So once the case was served, nothing really happened for a bit. Lawyers doing what they do, wait till the last minute to interact with you. And so I got a random email right after I had posted some videos about the maybe going into a default, and I hope that I don't win by default because I wanted to discuss the merits of the case. Shortly after that, I got an arbitration threat, an email from a bar card that stepped up and told me he is now representing the client in defense of this matter. And so I realized, oh boy, there's an arbitration agreement? I didn't know about an arbitration agreement. I did sign one, apparently. I didn't know much about arbitration at the time. When I purchased the vehicle, I signed an agreement that actually had a 30-day out clause in it. And conveniently, they gave me a whole stack of paperwork to go home with, but the arbitration agreement was not in the stack that I had and I had been working from. So when I built my case, I didn't know that I even had an arbitration agreement, which ended up being a major curveball, but I think also kind of a benefit in a way, which I'll get to here in a moment. So the videos that I had posted previously about this, I had to take those down. There was too much information in there that would violate the confidentiality agreement that I have signed. So I got the email from the lawyer threatening arbitration. I responded back using some case law and a few other details that I had the help of ChatGPT with. But I responded back pretty thoroughly and said, hey, go ahead and file it, but I'm going to respond. And this is basically how I respond. So nothing happened for a few days. And then sure enough, on the very last day, just like lawyers do, they filed the motion to dismiss, where the next day I would have been able to file for a default judgment. So they literally waited till the last day, the last hour to file the motion to dismiss, just like he said he would. And Great. Okay. Wonderful. That stinks. Let me freak out a little bit and figure out how I'm gonna fix this problem. So, just had to calm my mind a little bit, meditate on it, and realized after closer investigation that I had some good arguments here to oppose the attempt to compel arbitration. So that's what I did, and we ended up going back and forth. I filed a motion, they filed a motion. I filed another motion, they filed another motion. So we already rang up the billables quite a bit, which I think worked to my advantage because I showed them right out of the gate that I'm probably not your average pro se litigant. I am giving them a run for their money already. And then, boom, the judge rules that there is an arbitration agreement that stands. And you guys go to arbitration. We're not going to dismiss the case, but we're going to keep it open for another 60 days so that you guys can go to arbitration and come back and post the results. Great, right? That was a gut punch. So I was not prepared for arbitration. That definitely caught me by surprise, and then was not prepared for the judge ruling in the bar card's favor. But I should have assumed that from the beginning because we know how they all like to work together. It went maybe a week or two after that ruling where nothing happened. There were crickets, no contact from the bar card, nothing else filed in the case. And I was doing a bunch of research on arbitration and watching all the videos I could, and I realized that they must be waiting on me to make the next move, because whoever has the complaint is the one that needs to initiate arbitration. When you're tied in with American Arbitration Association, which was referenced in the arbitration agreement that I signed, they have a special form. And so I started filling out that form and prepared that. And in my research, I learned that the arbitration is really not ideal, and you want to avoid that at all costs. And remember in your contracts that you might be signing where you might plan to do this. Like if you're buying a new vehicle, make sure that you rescind that. If you're forced into signing it, you need to rescind that right away and not miss the boat. And arbitration usually sucks because only 4% of plaintiffs win their argument. And since they're all former bar cards and lawyers and judges that are now working in the private, their opinion is slanted naturally, and their opinion is a final verdict. It stands, and so you don't have the ability to appeal it like you normally would. There's many limitations that you'll find yourself in if you actually have to go to arbitration. So I paused, I took some time to think and meditate again on it and try to get some new ideas coming in. So figured out and planned the next move, which was to pump fake the arbitration filing by asking counsel, does this look good? Does this look okay? I was going to put you as the counsel, but I didn't know for sure if you were still going to represent the client in arbitration. And by the way, I'll consider a reasonable settlement offer. So just kind of throwing it out there, feeling a little weak, honestly, and coming in like a wounded dog, asking for help. And a week goes by, and then I finally heard back from the lawyer. He said, yes, my client has decided they would like us to represent them in arbitration. No comment about my mention of the settlement offer. So they totally ignored that. So I'm thinking, oh, great. Oh boy, I guess we're going to arbitration. So I had post the video about arbitration and owning it and saying, hey, we don't lose, we just win and we learn, and there must be something to learn here. So I'll take, maybe that's my job. I'll take you guys through the arbitration process and we'll talk about how it went down, and win or lose, we're all going to learn something together. So how's that sound? Not 15 minutes after posting that video, ironically, I did get a settlement offer. Not the settlement offer you might have expected, though. It was the lowball settlement offer of all lowball settlement offers. And so my immediate reaction was, those mother... Calm down, shut your face. There's something good here. Work with it, use it, figure it out. And so that's what I did. Got out the pen and paper, started writing down some ideas, went and walked around the park barefoot. Sometimes I get some of my best ideas meditating that way. I'm sure you guys have your own methods, but sure enough, I cleaned the slate, I calmed my mind, I got rid of the anger. We never make good decisions when we're angry, so great idea to just clean the slate, however you can figure out how to do that. And some ideas started coming in, and one of them was the mention of, hey, look at the email again. You see how he worded that question about arbitration? So in the settlement offer, which was an insult, it opened up with, Mr. Slater, have you filed the arbitration agreement with AAA? Please let me know when you have filed the arbitration agreement. And my client has considered a settlement offer. Here's the settlement offer. You pay us money. We'll give you a little discount on the balance, but you pay us and we'll let you keep the car and all this goes away. So that's why I was insulted. It wasn't anywhere close to what I was thinking. And I realized, you know what? They're at the table. They're willing to negotiate. Of course, hotshot lawyer isn't going to come in and just give the farm on the first offer. Of course they're going to lowball you. Like, what are you thinking? So that was the download that I got, and I realized, okay, this is good. This is good. They're at the table. They're willing to negotiate. Now, what are my options, right? So this is when I realized it was the major nexus point of the case. There was some kind of milestone that was important to the bar card with regard to going to arbitration. Like, he really wanted to know whether I had actually filed it or not. And that stuck with me for some reason, because once you do some of this, you realize these bar cards don't say anything by accident. Every word is crafted in a specific and particular way to get the end result or the effect that they want. And I think what he did there was actually showed a little bit of his hand unwittingly, didn't realize that I read into it and read in between the lines and realized, okay, you're worried about something. You want me to file that, but why? And I realized, there's billables here involved. And that's when I realized that you can totally use your pro se capability to go, you can file all the stuff that you want, but when they want to go file, the cha-ching, cha-ching, cha-ching. And what that means is it works in against the interests of the client every time that the bar card has to respond to you. So if you file a motion, they've got to respond. You do something else, they've got to respond. So if we're just going to arbitration, then that's a milestone for the lawyer to say, okay, billables here in court must be over. Okay, we can now plan a little better and only plan for what arbitration is going to cost. So he really wanted to know where we were at in that nexus point. Like, what's the plaintiff going to do? And I realized maybe he's worried that there's other stuff I can do. Well, let's consult ChatGPT. So some of the ideas that I had were, can I drop the case and just refile it? Because that's way cheaper than paying them, almost $10K to keep the car and make them go and make this whole thing go away. I'll just file again, keep them wrapped up in court. And maybe then I could have a chance to argue the arbitration better and include some things that I didn't realize, some constitutionality violations and whatnot. And it basically said, no, dumbass, don't do that. I get what you're trying to do. Here's what you need to do. So I'm like, ChatGPT, okay, what do I do? And it gave me some really sound advice, actually. Granted, I'm not using standard ChatGPT. I'm using a custom GPT that you'll find in the GPT library. And if you've gotten a consultation from me on a one-on-one, I've probably recommended this particular one. I'll put it up on the screen. It's called the Rebirth Legal Navigator, and it's already preloaded with Supreme Court law, case law for all the states, and it understands negotiable instruments and all of this stuff that you'll find in this category of knowledge. And so it empowered me to at least know what else I could do and maybe what the bar card was worried about. So I took that advice, which was basically, you can still modify your petition, you could increase your damages, you could file a motion to set aside the recent ruling about arbitration, may add in some new facts about the constitutionality issues where it violates the Arizona Constitution by compelling arbitration and giving up your right to a jury trial. And so I realized, okay, great. Now I know what to respond back. Now I know what magic words to use in my counter offer to their settlement attempt. So what I did is I took everything that I learned in ChatGPT and I served it back to the lawyer in an email that said, hey buddy, I'm not paying anything because this was already paid off via the Uniform Commercial Code, Arizona Title 47. This loan is already discharged. And I actually realized by your math here that I miscalculated the damages, so I'm going to file a petition to modify, and we might even have to go to oral arguments because of that. I'm also going to file a motion to set aside and vacate the ruling because I believe the judge overlooked the constitutionality issues. And then if I don't get what I want on those two things, I'll just do a special action petitioned appeal, which makes the appellate court look at it right away because there's something urgent in regards to that, which might also compel oral arguments, which is really expensive and would have to get opposing counsel into the courtroom with me. So win or lose, I was able to show them that I knew how to continue to run up the billables before we even go to arbitration. And I think those magic words in that email where I had said, look, here's what I'm going to do, and I'll take it to the special petitioned appeal if I have to. But maybe we could avoid all that if your client's willing to consider my counteroffer. So here's my counteroffer. You pay me money in damages, release the lien on the vehicle, and then fix the credit entries and mark the account as closed. Within 2 days, got a response back that basically said, we accept your offer. Here's our offer. And it was exactly what I asked for in my most recent email. So I was jumping around and hooting and hollering and around this room. That was last week. I was super excited, and then I posted an update right away on the group because I wanted everybody to know, like, hey, we reached another milestone. It looks like we're settling. And now I'm recording this without sharing any details. I did already sign the confidentiality agreement. I'm not supposed to talk about this stuff or talk about the case or the details of the settlement, but I think if done in the right way, I'm not sharing any particular details, nothing specific, and I've changed the names to protect the guilty and complicit. So we're here now. I have signed the paperwork as required yesterday. Within the next week, they're required to get me the lien release, which comes electronically, and then I'll be able to go retitle it down at the DMV. And then the credit issues will be repaired, and then I'll get my settlement check for the damages, which was about maybe a fifth of what I was asking. So you could do the math on that. I was asking for $30K in the damages in the complaint, but ended up settling for a bit less. I would have actually just really been happy with proving a point through them releasing the lien on the vehicle. So what I was able to do is not give up, look at all my options, figure out how to use the billable hours against the client so that we could compel performance without having to go through the whole court argument process. I believe that they felt there must have been enough merit to the argument and the way that I structured it that they were not convinced that they would just win in arbitration, even though it is heavily slanted towards the defendant that compels arbitration. It's very rare that the plaintiff wins. The defendant usually has the upper hand in arbitration disputes, and they were still not willing to compel arbitration and actually go all the way through with it. So my settlement offer was promptly accepted, and here we are. The loan on the vehicle, which I was upside down on, the loan was way more than the vehicle's worth, so maybe that had something to do with it. Not sure if you'd be quite as effective or if it would be that easy to get to a settlement if you bought a $100,000 Mercedes and then made 2 payments and then went and gave them a negotiable instrument and took it to court. They might fight that a little harder, who knows, but still it shows that there is merit to this argument. You could do this too. Start with a payoff statement, endorse that payoff statement, tender it via registered mail, and then let them damage you. Quantify the damages, turn that into a complaint. I'm going to sanitize my complaint so that you can take the same framework I've used without me giving away too many details about the lawsuit and the strategy with who it was involved with. You can just take the steps that I took, adjust it to your state's U.C.C codes, swap that information out, and then go to town with it and file your lawsuit and see what happens. So that's how we got here. I basically just used the billable hours against them, threatened to keep this going in court as long as possible, and they caved on my settlement offer, which I'm up $20K because I owed at least 15 or 16 on the vehicle, and then they gave me the difference in damages. So I got some damages, cha-ching, and I got what I wanted with no more car payments, and I think you guys can do it too. So that's how we did it. Any questions, let me know. If you want a consultation on this stuff, I do that. You can find that on the website. And if you want one of these stamps to get you started, got that on the website as well. And that just keeps it official, makes it impossible for you to mess up the qualified endorsement because you need to sign as an agent for the principal, basically. And that's how we do it. So hope to hear you guys having some success soon as well, and we'll see you on the flip side.